Welcome to our discussion of impeachment, the second impeachment of Donald J. Trump. We're going to discuss whether the court, not the court actually, but can Congress try a president who is out of office. Come along and let's study history and law together. After the recent events of January, and we're still actually in January of 2021, it gives us an opportunity to, after all that we've gone through, to figure out exactly some of the history of the Constitution and the history of the Electoral College. We're going to try to analyze the various amendments, the 12th Amendment, the 25th Amendment, and most of the time we're going to spend on impeachment. I think most of us know that actually, in theory, citizens of the United States do not choose the president. Almost every other office in this country, on the federal level, unless it's an appointee, is chosen by a majority of the individuals of that state. Now, it's true that the president technically is chosen that way, the way it's set up, but it's really chosen by the electors. We vote for electors, and those electors are chosen to go and represent the state with regards to who they choose as president. So in essence, the states actually decide who becomes the president. We choose the electors, and the electors representing the state decide to put forward who they choose as president. Before 1800, really before 1804, the way it worked was that there were two choices, and they were made by representatives, etc., whoever the electors were, and the one who had the most votes would be the president. The one who had the second most votes would be the vice president. That caused a constitutional issue in 1800, trying to choose who would become the president and the vice president. There were equal votes for Thomas Jefferson as well and Aaron Burr. And basically, because of this tension, they came up with the 12th Amendment, which, interesting enough, just came up as a discussion over these past few weeks. Okay, so as we discuss the 12th Amendment, really the main purpose of the 12th Amendment was to have electors separate for the president and separate for the vice president. So we wouldn't get into a tension between a tie between the president and the vice president possibilities. Also, we would avoid having a president from one party and a vice president from another party, which sort of existed in 1796 with John Adams being president and Thomas Jefferson being vice president, where at the time John Adams was part of the Federalist Party and Thomas Jefferson was part of the Democrat Party. Now, the issue that came up in this cycle was that the president suggested that the vice president has a right to choose or to actually neglect or reject various electors from various states. And that was sort of the question. And the issue is, can that really be read in the Constitution itself? So personally, I think he had terrible advice, because the reality is it's very hard to read it differently, because it says in the 12th Amendment that the president of the Senate, who actually is the vice president, shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. So the fact is that the vice president or the president of the Senate has no choice to decide which to reject or not, because the votes shall be counted. That is the only thing that he actually can do. Now, it's fascinating that the 12th Amendment discusses, let's say there aren't enough electoral a majority, okay, there isn't a majority, and perhaps that was part of the president's and his lawyers thought that if they would reject few, there would not be a majority, and then it can be decided by the House of Representatives. Again, this is also discussed here as well in the 12th Amendment. It's fascinating. In our system right now, it's still possible for the House of Representatives to choose a president in our numerical situation where there would be a 269. That's at least the way it's set up right now. And actually, on the night of the election, there was such a possibility, was still in the minds of people, of that possibly happening. Again, just to continue the idea of the 12th Amendment, at that point in time, the top three candidates would be thrown to the House. It would depend not upon the numbers in the House, but it would depend upon the states in the House. So each state would get a vote from perspective of the House, and that's how they would choose a president. Again, this issue of the 12th Amendment just, again, recently came up. It seems to be a clear reading from the Constitution that there is no power from the perspective of the states, from Congress, to make a choice in the matter. What they can do is only bring forth what the states have decided. Now, if there are issues of irregularity that you might have complaints about, we generally follow the concept of res judicata, that the matter has been decided. The states themselves have made that decision. Even you might disagree with the state's decision, it really doesn't matter. The states are deciding, and the fact is they can decide how they want to decide the actual electors for that particular state to be sent to Congress. Now, that doesn't leave out, and I'll leave this point, that doesn't leave open the concept of having investigations. States and Congress are allowed to look into irregularities. For example, we found this by Watergate. Once the president was out, he resigned, Nixon, because of Watergate. There were investigations looking into the issues of Watergate. So with regards to the 12th Amendment, it seems clear that the proceedings was done correctly, that the vice president has no power to decide or to reject electors, and it's really just for the purposes of counting what the states have decided. At this point, I'd like to discuss the 25th Amendment. This has been brought up in various situations, and the fact is the main function of the 25th Amendment was to solve a problem that, again, the Constitution had, and that is that when a president dies or leaves office before the term is up, who becomes the president? It wasn't clear, but John Tyler sort of made the decision once William Henry Harrison died that he would be called the president, and there was a lot of discussion about it, but it was sort of understood that after his decision making, and again through history, that if the president dies in office, that the vice president becomes the president. The only issue was, well, what about another vice president? Let's say this vice president would have to be removed from office. How would that work? So basically, they decided in the 25th Amendment, really after the death of John F. Kennedy, they came up with the following system that technically the vice president becomes the president, stated, and the vice president would be chosen by the House and the Senate, a majority of the House and Senate, and that's how a vice president would be chosen, which is made an anomaly in history that we had a president named Gerald Ford, who was neither elected as president or vice president, who actually became the vice president and the president. Now, the truth was we also had a vice president who was not even elected. That was Nelson Rockefeller. So that amendment almost went right into business after the resignation of Richard Nixon. So now I'd like to discuss Section 4 of the 25th Amendment, and that is, can the vice president and a majority of the officers of the executive departments could actually rule and state that the president is unable to discharge the powers and duties of his office. This is what's discussed in Section 4, and there's a whole procedure of days of how to work that. For example, the president can write and say he is able, and then the vice president and this cabinet, if they still want to continue this, have 4 days to respond. And then at that point, there's a 21-day period in which the House and the Senate could determine whether or not the president is able or not. They would need 2/3 of the House, which is actually much higher than a standard impeachment, and they would need 2/3 of the Senate under that circumstances. This is a long, long process. This was sort of discussed, sort of brought forward as a possibility of the situation of whether during the riot at the Capitol, as well as the situation of where was Donald Trump with regards to all of this, that there was some suggestion that this should be done. The reality is we talked about a small period of time, of a 10-day period, and the question really was, did it fall under the understanding of what the 25th Amendment was trying to accomplish? What is unable to discharge the powers? It probably meant more a situation where, for example, a president had a stroke. And this is sort of a discussion about the last 2 years of Woodrow Wilson after he received the stroke. Would an amendment like this would have been forward or not? Who was actually making the decisions with regards to presidential decisions after World War I with Woodrow Wilson's stroke? However, this is a very fascinating conversation. But the issue is whether or not this was really the case with regards to President Trump at the time, whether he had an inability. And the question is whether that can really be read in, just because you might be afraid that he might be volatile or something like that. So it's interesting that it was brought up. And here again, something like the 25th Amendment was also brought up in the discussion. Now I'd like to spend most of our time on the issue of impeachment, because that is really what's happening at this particular time. What does the word impeachment mean? Actually, the word impeach comes from the word prevent. It's a power that is given to Congress in Article 1 of the Constitution to actually impeach various officers of the government. And let me read for you the important sections that deal with this in Article 1. Again, Article 1 deals with how old somebody in the House of Representatives has to be, and all those powers that are given to Congress in 1. So in Section 2, the last statement is, the House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. They have sole power of impeachment. And we'll discuss a little bit more what that means, but it seems preventing one from coming into office. Let's go a little bit further in Article 1. At the end, it says, with regards to issues of the Senate, it says, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So that's one section. Again, the Senate has a sole power to try, and they have to take an oath, and it is to a president of the United States. When that happens, because they have a right to try others as well, the Chief Justice shall preside under those circumstances, and they have to have a conviction of 2/3 of the Senate. A little bit further, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So just having an impeachment and having a trial and being thrown out of office doesn't leave out the possibility of other indictments outside of that. One other point, Article 2, Section 4, which is dealing with the presidential powers, it says, the President, the Vice President, and all civil officers of the United States shall be removed from office on impeachment for conviction of treason, bribery, or other high crimes and misdemeanors. So the very specific language that is used both in Article 1 and Article 2, we will delve into this specifically with regards to the issue of, which is really I think the main issue we want to discuss, is can somebody who's no longer president be tried? Okay, now we're going to look a little bit at the language of impeachment and the question of the article of impeachment. It's actually not so long, but I'm not going to read the entire one article of impeachment, but the main issue is incitement of insurrection. So these are two very important languages. What is insurrection and what is incitement according to the law? So usually insurrection means a rebellion of citizens or subjects of a country against its government. Usually rebellion is more of resistance, revolt is overthrow. So the real question is, was there insurrection here? Was the purpose of, again, we have to get to the incitement, but was this to overtopple the government or to not follow various laws? So the term insurrection personally might have been too broad and not on point. The fact is that it might have had some political reason, but the fact is, if you can think about it, would a language of incitement to riot could have fallen under the high crime, as it is a high crime to attack the Capitol. So riot might have been enough for the purposes of high crimes and misdemeanors. So that's worth thinking about. Whether the House was too quick to use that as a term, maybe they should have used two articles, one of incitement of insurrection and incitement to riot. So that's worth noting. Now we have to go to another question, which it seems that it might be tried depending upon if there will be a trial in the Senate. But the fact is that what is incitement? Is there causality between the language that was used at seemingly the rally before many of the individuals who were at the rally went towards the Capitol? What actually was urged? What was the language that was used? That will take a long time to look at. That would require a lot of information. The fact is, it seems, as we'll discuss, that the House wanted to quickly put forward an issue of impeachment, and we'll see perhaps maybe why they wanted to do that, but we really have to ask our question, does the language in the article include all the language that was used by the president? It doesn't. And the issue is, there's all causality. Who listened to what? So there are many moving parts. You're dealing with, would have been much more complicated, easier to understand if it was maybe a few days before, but there seems to be, where was the causality between the words itself and others? Another important case to look at, where this is sort of discussed from a law perspective, is the case of Brandenburg, which was, I believe, versus the Ku Klux Klan, and the issue of what a First Amendment right to state, or in a political situation. For example, Brandenburg said, is it directed to incite or to promote incitement or lawlessness action, and is likely to produce such action? So the issues here that are worth thinking about is, number one, incitement, and number two, insurrection. So let's discuss from a historical perspective the issue of trying somebody who is not in office. So when the Constitution was actually being written, there was a trial and an impeachment issue that was going on, that if somebody was impeached in England at the time, Governor Hastings, who was the former governor of India. Again, that was one case. So while the Constitution is being written, there is a discussion, at least in England, a thing going on in England, that a person is in office. Now, it's very possible that for that reason, the Constitution did not want to follow that aspect, and therefore we can look at the language. But we do have two cases of within a 200-year period where we do have impeachment. Now, the fact is, impeachment has been used very little. I mean, over time, there are less than 20 cases of impeachment. Many times individuals leave office, many people resign. We avoid impeachment. I mean, Richard Nixon avoided impeachment. So there are ways and situations where we don't have to deal with that power. But the fact is, a very famous case in 1885 for a general, his name is William Belknap, who was a general in the Civil War, very close to Grant. where there was a Trader Post scandal, and he actually had left office and they impeached him. But many in the Senate ruled that not to convict him because the House did not have jurisdiction in the matter because he was out of office. So there's not much history around the situation of whether or not impeachments can take place legally after somebody's out of office. And we're going to look right now and discuss within the language of the Constitution those who feel there should not be a trial and those who feel there should be a trial. Okay, let's begin and look at the language of the Constitution for those who feel that there should be no trial of former President Trump. The fact is that the Senate has the sole power to try all impeachments. Now, impeachments are what we call, similar in criminal law, a grand jury. That's the House sort of comes up with articles of impeachment or basically possible violations. And then the Senate tries it like a regular jury. Now, the language says, when sitting for that purpose, okay, they shall take an oath, that's fine, when the President of the United States is tried. He is not the President of the United States at this point. The President of the United States is Joe Biden, the 46th President of the United States. He is no longer President. He is a private citizen. So the issue is, he is a private citizen, so there is no way of trying him at this point. And that is also true with regards to Article 2. The President, Vice President, all civil officers of the United States shall be removed from office on impeachment for, again, they have to be tried, they have to be removed. Here the issue is, he's gone. He's no longer in office. Now, again, in Article, in the end of the article, in Article 1, Section 3, it says the following language. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Now, the questions we'll discuss, and those who feel you can still trial, is this phrase one inclusive phrase, meaning that part of the only thing that a trial can do is to remove them from office, disqualification to hold and enjoy any office of honor. They are in office right now. We can remove them. We can prevent them from retaining the office which they have right now. The president, the former president, is no longer president. He no longer retains that office. It would be similar to a person who was at a trial, and the fact is the person had died. He's no longer alive. There's no reason to try the person. Now, we'll discuss now, maybe there can be other language be read into this and maybe other reasonings behind why the president could still be tried. Now, there are those that would argue that the former president could still be tried. Now, first of all, is a good understanding the question, which would be worth noting, is that does it matter that he was impeached while he was president and that he left at that point? Would it matter? I think it's worth thinking about. Let's say they decided to impeach him 3 months from now or 4 months ago. Would that have been okay? Meaning, and maybe if you think about it from the perspective of the House who wanted to impeach him, they might have thought out more of what to impeach him for without getting this quick language out. Now the question is, can they, in addition, were they allowed to have other articles of impeachment at this point? It seems to me part of their argument is that, well, he was impeached before office. That is worth noting, and whether that matters or not, it doesn't matter at this point. The other issue is, what are you trying to accomplish? So it could be argued from the perspective of impeachment and what you're trying to accomplish. The reason is to avoid this individual coming back to office. Question. So since the president only had one term, and according to our Constitution, he can have a second term, would there be a need to actually have him avoid and disqualify him for further federal office? And maybe one could argue, yeah, there's room for that. There is some history behind that, and therefore there would be a need to do that particularly. And then you would have to read the language of the Article 1 to say, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office. So you'd have to read that as or disqualification almost, and that not to take it too literal, but you need to disqualify him for the purposes of having office in a further situation. I will add, and something to think about and reflect upon, is that maybe in the situations in history that we had beforehand, those were appointees, right? The question here is that if you decide not to go through the impeachment and go through trial, really what would happen is it would come up to the decision of the people to decide whether they want to vote the president in again. Now, that's a very good question to think about, but all in all, according to this approach, those who feel that a trial can take place, that it can take place because the president was impeached, and the reason behind impeachment, and there's some history behind it, is to avoid this individual to come back into office, and that could still happen even if a person resigns. So they say that would be like unfair, like a person gets into trouble and right away they're about to impeach him and he resigns. So, it doesn't serve the importance of the purpose of having impeachment and having a trial. So now we're going to look at the issue of any jurisdictional challenges. Now, is the impeachment trial follow Article 1, that Congress, or does it follow Article 3, and that is the judicial branch? Does the judicial branch have a say in the matter? Can there be jurisdictional challenges? So right just off the presses, the fact is, who should make this decision? So the language of the Constitution seems to say that when a president is being tried after an impeachment, who presides? The Chief Justice is the one who presides, and that would be Justice Roberts. So through our history, recent history, so we had Chief Justice Rehnquist, who tried the Bill Clinton impeachment, and we just had this past year Justice Roberts. Justice Roberts has denied wanting to, is that the right word, denied? He has decided he will not try this case, and probably has the language of the Constitution stating that he doesn't try this case. Now, he might even have, it's interesting that they're continuing to have the trial, it seems, but the Chief Justice could actually say that there is no jurisdiction in this case, and that he can only preside in a situation where there actually is a president, and therefore the president is not here. Therefore, number one, he can't preside, and number two, it's a question whether or not they have jurisdiction. Now, this is a very good question of whether or not, who makes the decision of whether legally there can be an impeachment. Now, the reason why this is important is because whether or not an impeachment takes place, which it has, and a trial takes place where the former president can no longer go into office, who makes the decision? Is that binding on him, or can the courts look at that issue of jurisdiction or not? The fact is that the judges, the Senate are jurors in the case. They've created a pro temp, somebody else who can sit, because they're claiming that this is not someone who is president and therefore can fall under other articles of impeachment. But really the question is, will there be jurisdictional review? In 1993, there was a case for Judge Nixon, no relation, I think, to the other Nixon, where the court said that they can decide how to try a case, meaning the Congress can decide what rules to use for trying. It doesn't have to actually follow rules that follow in courts of law. However, it could still be, it's very possible, that even though the Supreme Court said we're not going to decide how you deal with those issues, but with procedural issues, which one of this is a procedural issue, is whether or not a trial can take place under these circumstances if the president is no longer president. And we might see that such, before the trial goes forward, which probably is going forward in February, whether or not there will be documents sent to the Supreme Court to make a decision whether or not the former president can be tried on an impeachment. So I'd just like to close and say that it probably will go through. The questions we will look at and see whether or not there will be challenges, and it'll be worth watching. We as a country will be watching this, and the question is, what can they do? So really, all they can do is really convict and disqualify him. The important thing is that they cannot cripple the office itself, meaning they can't say that, okay, we disqualify former President Trump, and if he comes into office again, we will limit his powers. That's not what they can do. They can censure, which could have happened also before the president left. But the only thing that they can do is what the Constitution says. The Constitution says that all they can do is remove him from office, disqualify, to hold and enjoy any office of honor, trust, or profit under the United States. That's all that they can actually do. So we will wait and see. I highly recommend, if you'd like to look a little bit again at some of the language of impeachment, this is a fascinating debate. There's a lot of emotion around this, and we will see what happens, and we are living in the middle of history. Thank you all for coming.